Hello, everybody. This is Leonardo Alberto Lopez Marcos. I'm an attorney at law and economist. And as you can see, also, I'm a doctoral research fellow professor at Complutense University of Madrid, a core member of the Spanish Association of Air and Space Law. And today, what we are going to talk about, we're going to talk about space sustainability based on international space law. That's our approach. Of course, this is very interesting because we are coming from the main space conference where I I was in this panel on space security. So also we could see that space security is a dimension of space sustainability. Without a clean outer space environment, we cannot talk about no threats. We cannot say that outer space is free from those threats, right? We are talking, for instance, about space debris. So what we have here, it's very interesting. We usually tend to assume that Earth is that blue dot, right? Amazing, beautiful, great, but it's not that. So there is an important and interesting data that shows how space debris has been increasing through all the decades. So, you have to realize when the first communication satellite was launched, which kind of satellite launch are we talking about? We are talking about the ECO-1 in 1961. This ECO-1 in 1961, it was a passive reflector, right, telecommunication satellite. In that moment, in 1961, just in mind for a moment, there were only 13 space objects in outer space. These include debris and active satellites. Now, the amount of space debris plus space objects and so forth, it's it's a lot. If we compare when the ECO-1 in 1961 was launched, I just said that there were 13 space objects. Now there are, I think, more than 10,000 nowadays, or approximately more than 10,000 active satellites. And this amount of these numbers, let's say, are meant to be increased. For instance, we have this projection, this future perspective of Starlink satellites, more than 30,000 Starlinks by 2030. We do have all their mega constellation of satellites. What are we talking about? For instance, OneWeb, I think it's around 600 to 700 satellites. We also do have the Chinese SatNet, around 10,000 satellites. We have Kuiper from Amazon, already. It's going to be 3,000 satellites. So, more, we are talking more active satellites, more space objects, and on. So, in the end, there is another important number that reflects how much are we using from those space objects and how much space debris we have. This 1%, and this is fascinating, this 1% of all space objects are active satellites. The rest is just space debris. And of course, when we talk about space debris, we are talking about intentional debris. For instance, we are just talking about breakups from space objects. That's pretty normal, when you launch the object. Also, you have this intentional, non-intentional. Non-intentional, it's just breaking up, because it passed time and so forth. But then you do have this intentional space debris, right? And as you can imagine, we could have two sides, which is stages of space rockets. These phases of space rockets. Although nowadays with these reusable rockets, for instance, right now, of course, the rock star of the space industry, SpaceX, these reusable rockets, it has been reduced, this kind of space debris. But we do have other thing, which is militarization of outer space, meaning anti-satellite test. That's the main thing, right? Anti-satellite test or missiles test. That's, let's say, the main problem, that it can create clouds of space debris. That's the main problem. And the more space debris we have, there is this syndrome or this effect that everyone's called the Kessler effect. And the more space debris, the more chances or more probability that those objects, let's call it objects, space debris objects, can clash with others, and this domino effect that create like from small debris to mega clouds of space debris. And the problem of this is that reduce the capacity or the capability, let's say better, of states and private actors to access to outer space, because it's useless outer space, or let's say Earth orbit, if it's crowded by space debris. Now, some people, they usually say, well, just 1 millimeter or 1 centimeter of piece of space debris, that's nothing. It could be literally as this cap, right? The problem is when you go to outer space. That's the main problem. I don't know, guys, you about the metric system in America, in the USA, but we do have kilometers and so forth. So there are bullets. This in outer space is a bullet. It can cross through it can go through the helmet of an astronaut, through the suit. It can damage and disable satellites. Even the International Space Station has maneuvered many times, right? And also the Space Crew Dragon, the capsule, has been not maneuvering, but almost collide with some of these space objects. So, I mean, this is actually very interesting, because they can travel to 20 to 30,000 kilometers per hour. That's a lot. It's a bullet. So careful, when we talk about this. So in the end, we have intentional creation of space debris, breakups from space objects, also, let's say, anti-satellites missiles, right? And then, you have others which are more non-intentional. It's because of the time, because of the let's say those breakups that I mentioned earlier is more non-intentional, is due to the let's say the survival of the life of the space objects per se in outer space. At some point, you just get non-functional or disabled, etc. And then, of course, you have the intentional. What I meant by intentional is those stages of space rockets, also these ASAT tests that I just mentioned, and then they can be reduced by the will of the states. For instance, investing more in reusable rockets, right? Or not taking those missiles to outer space. So this is what I'm talking about, space activities. The space activities can create a large amount of space debris. And that's simple, right? Most common example is this military use of outer space. We do have ASAT test, anti-satellite test or missiles, right? Basically, launching a missile to outer space, it can be kinetic, non-kinetic. We are not going to get there. And then it can either explode or just strike a space object. Of course, this creates a large amount of space debris, especially when the test or the missile has like a reaction, like an explosion. Well, many states have been, let's say, carrying this kind of test. This is not only from the USA or the Soviet Union, the former Soviet Union, also Russia in 2021, China, and India. The problem is, if this uses of outer space, military uses of outer space. I mean, this is totally lawful. We have to say that because we are not striking down, or we are not shooting down, sorry, a satellite of another country. That could mean an act of war, an act of aggression, and then apply the right of self-defense or the law of armed conflict. We are not going to be there right now. So the problem is when this missile test, asset test, create long-lasting space debris. Some countries, especially India and the USA, it wasn't that much clear with India, but they conducted in this century several asset tests. Well, several. One the USA and the other India in 2019. Um, the altitude was lower than the Russian and especially the Chinese asset test. So this means that it's supposed they are not going to create long-lasting space debris. They are not going to be a threat to other space assets, including humans, life in outer space, International Space Station, and other commercial space stations that they are going to be created, and also the Tiangong Space Station, the Chinese, the infrastructure in outer space, other active satellites. They are not going to create long-lasting space debris because they are very in low Earth orbit, so they are going to be removed naturally by the gravity of the Earth when they re-enter, right? So, but it's very interesting how, for instance, the asset test conducted by Russia in 2021, it created a large amount of space debris close to the space station. It increased more than half, and double the space debris around the International Space Station. That put in danger, for instance, the crew from both sides, the Western part and also the Russian part. So they went to this called shelter mode of emergency. And these people, for 2 hours, they stay in the International Space Station in their capsules, try to expecting whether they were going to leave or not the International Space Station in emergency mode, because due to the in November 2021, when Russia conducted this missile, they didn't know what it was going to happen. Just imagine that all people there died, the members of the International Space Station. So for us, probably it was just 2 hours, just probably a Netflix movie or something. For them, it was quite different. I bet. I mean, I cannot even imagine what they were thinking about for 2 hours in that shelter mode or emergency mode, however it's called, right? So careful with these things. And of course, what we talk right now is that there could be a conflict in outer space. That's another dimension that we are going to tackle later in the dimension of the space sustainability, which is space security. So large amount of space debris. Also, it happened with the Chinese asset, 2007, 2008. I think it's 2008 right now. The problem is that this asset test was conducted, I think, at 850 kilometers, around 800, above 800 kilometers. It has created long-lasting space debris that will last for centuries in outer space until it can be forced to be removed, as I talked earlier with Leo, with the low Earth orbit. And that's a problem. Now, there is another problem when accidentally we shoot down someone else, let's say another state space object or space. It could be a space object, a commercial space station, a station, even a habitat in the future, a human habitat, settlement. It's important because then we can apply the law of armed conflict. It can be understood that there has been an act of aggression, right? So then the other state can activate the right of self-defense under United Nations Charter, and or to justify the war or to prevent the war. Once we get into the war, which is called the jus in bellum, the other is the use at vellum, the use in vellum, then all the law of armed conflict that apply on Earth also applies to outer space, and that has been said by the International Court of Justice when it said that the law of armed conflict applies to all warfare domains, right? And the law of armed conflict is not about it is well, is about to is a set of international rules that dictate how to make war, or at least to humanize war. So of course we cannot shoot down all the space objects from our enemy, because it could not surpass, let's say, or pass the test of distinction, proportionality, humanity, efficiency, etc. So careful, because the law of armed conflict applies to outer space when we escalate in the conflict from an as a test to a war in outer space. There are rules, just so you know, that they apply. And also these rules has a direct impact in the quality of the outer space environment, right? We do have other uses of outer space that can damage outer space. We are just not talking about military uses, that they are more associated to states. This, as you can see, we have the space industry, non-state actors or non-governmental activities set by the Outer Space Treaty. We want to use the correct language with this, right? Private companies, space companies, space tourism. We are going to have a set and a bunch of emerging activities, in the emerging space industry, that they constitute just 1% of the entire economy investment, let's say. So this emerging space industry is made by, for instance, space tourism, human space settlement, cislunar economy. We also do have these in-orbit services, refuel stations in outer space, and on and on and on. We even have active debris removal that we are going to see later. But what is more important is just not this emerging space industry. For instance, space tourism, we have Blue Origin, Virgin Galactic. We have space perspectives now. And on, right? Well, SpaceX is not their main focus, right? Space tourism, but it has launched several initiatives there. Now, it's right that this emerging space economy is trying to create a space-based customer. The main customer of this emerging industry is not going to be on Earth; it's going to be in outer space. Now, there is another point. The classic or traditional, that's something that we taught in the main space conference. The other day in this panel of international space economy, national space economy, these perspectives to them. It's the traditional space economy. What is the traditional space economy? Satellites and rocket industry. Emerging industry, we have said that it accounts the total investment of the emerging space industry that I just said, 1%. Rocket industry, 10%. 89% is the satellites, right? So we have these projections that I just talked about, the SatNet, Kuiper, OneWeb. We also have Starlink. So the problem is that the more crowded gets the Earth orbit, the more probability could happen that there is a catastrophe, an event that create a massive cascade of collisions in outer space. That's why it's important to, as we are going to see now, to use new methods, new techniques to deorbit those objects, or at least the biggest ones, more than 10 centimeters. I think there are around 36,000 more than 10 centimeters objects orbiting Earth. So we reduce those threats to the outer space environment, right? So we are focusing now in the satellite industry, and of course in the rocket industry, because of the stages of rockets, they are still there. But the growing space satellite industry and the growing number of space active satellites in Earth orbit, right? So as I said, this is important because we could develop new techniques that deorbit those or the most important space objects that can cause a huge threat and risk to the survival of several space objects, human lives, and all. As I also said, you can see in this image, we also will see it in the robotic arm of the International Space Station. Um, just a piece from 1 millimeter to 1 centimeter that they are more than a million uh, orbiting Earth, they can cause severe damage. They can disable a satellite or they can kill an entire crew of a commercial space station, for instance, in the future, right? Orbital reef. So careful with these small, once again, careful with these small space debris objects. They are not, I mean, they are pure danger. So careful with them. And then I create this image in your mind on how dangerous is space debris. So now, what do you think? What do you think is the next step when we talk about space debris, commercialization of outer space, militarization of outer space, the negative problems that they affect directly to the quality of the outer space environment? Because we have to think that without a healthy and a quality environment, we cannot consider a normal development, let's say, of the space industry. We cannot freely access to outer space. We cannot use outer space. Probably even the investment is going to be lower because there will be more risk to take to access to outer space. Even the space insurance will charge even more because there will be a high probability of collision if we do not protect outer space environment. And this question or these issues, of course, it leads us to consider, well, is the protection of outer space really safeguarded? What do we have now? What can we think about? Which kind of solutions as space lawyers, right? So first, you have to do something that not many people like. All right, we have to experience what is called the interpretation technique. We have to go to see in the legally binding obligations, international legally binding obligations, if there is anything, just anything that protects outer space. Because protection of outer space means sustainability, a more sustainable environment in outer space. So, when you talk about this, you have to go to the Outer Space Treaty, but you have to interpret Outer Space Treaty considering the Vienna Convention of 1969. And then I heard many people, scholars, I also have heard politicians, diplomats, that they still think that Article 9 of Outer Space Treaty unveil a world full of possibilities in the protection of outer space environment. And that's not true. Sometimes it's called the green clause. That's totally wrong. That is wrong. Uh, to get to this conclusion, to figure out that outer space environment is not legally binding protected under the Outer Space Treaty, because we'll see that in the Moon Agreement, it is. We have to understand what is forward contamination and backward contamination in general terms. Forward contamination, all the contamination that we export to outer space. It can also mean space debris, chemical contamination, nuclear contamination, everything, all the contamination that we export from Earth to other celestial bodies, to other outer space, atmospheres or layers of atmospheres or orbits, let's say, to other celestial bodies. Backward contamination is the reverse, all the contamination that we bring from outer space. Of course, we are including here both forward and backward contamination, biological contamination, the things that we can bring from outer space to the Earth in terms of biological contamination, for instance, but also the form of biological contamination that we can export to the ecosystem of other planets. That's right. So Article 9, if you take a look there, it doesn't say directly, this is forward contamination, this is backward contamination. Of course, what I'm saying has a legal argument and is not, I mean, is controversial. I'm aware of that, of course. So if you have any questions, please reach me out. You have my email at the very end of this presentation. And for sure, Rebecca will give you my contact. So Article 9 said, well, when you use outer space, right, it says state parties shall pursue studies of outer space, including the moon, other celestial bodies, and when they do that, they have to avoid harmful contamination and the adverse changes in the environment of the Earth, from the introduction of extraterrestrial matter, biological contamination, and adopt appropriate measures and so forth. So here, first you have harmful contamination of outer space and celestial bodies, and on the other hand, you have adverse changes in the environment of Earth. Harmful contamination means chemical contamination, right? Is a kind of forward contamination. So it does harmful contamination. It does not include space debris or other kind of contamination. Only chemical contamination to outer space. On the other hand, it says adverse changes in the environment of Earth. This means biological contamination to Earth, backward contamination. Only that, only extraterrestrial matter. We are not talking about intelligent life, right? We will see later, though, intelligent life in outer space. So, just focusing here. Space debris is not included in Article 9, so this is very important. That's why we do have all the long-term sustainability guidelines and all space debris guidelines, mitigation guidelines. We have a lot of documents, non-legally binding, resolutions non-legally binding at the international level that include space debris, because space debris is not included under Article 9. It only includes harmful contamination, chemical contamination of outer space and celestial bodies. And this is very important to understand. Now, in the Moon Agreement, Article 7.1, it says harmful contamination and adverse changes in the environment of the moon celestial body. So the Moon Agreement, it really includes the possibility of protect the moon and other celestial bodies. It excludes the vacuum of outer space, this is important to say. It protects against forward and backward contamination in their general terms, which includes chemical, nuclear, space debris, and all. Okay, so what is the problem now with the Moon Agreement? Pretty simple. It's a treaty under international law. It's valid, right? But it's an international treaty. It's valid. It's not a failed treaty because when you read the literature, when you hear people saying that it's a failed treaty, it is not. It is legally binding and international law. The only problem is that a few state parties they have ratified this Moon Agreement, and not even the spacefaring nations. So now we have a problem. Outer Space Treaty does not protect outer space and its celestial bodies against space debris. Now we have probably the Liability Convention from 1972. This is just focused on the damage that can cause, caused by lawful, take a look here, lawful activities, right? But when you take a look inside the Liability Convention, when you analyze these damages, the concept of damages, it does not include any environmental damages. However, if you scroll down, let's say, instead of opening, I have some books here, instead of opening, you go through internet and use the Reliability Convention from 1972, and you scroll down, you will realize Article 21. And it's talk about, I remember, vital centers or human centers that could also constitute some kind of environment, right? Or ecosystem around cities. That includes the term of damage. Now, it does not refer uh, it refers to these earth or vital centers where humans live. This could, that's what I wanted to say. This Article 21, it's interesting because it could be applied in the future to the protection of the surroundings of the human space settlements. That's something that needs to be developed, of course, and I've been trying to develop, but that's a very interesting and important concept there. So what are we talking about here is that there is non-legally binding instruments, meaning treaties, um, that we will see later the possible solution that protects outer space against space debris, for instance, right? Now, what is the problem? That each state, I think right now there's 42 space legislations in the world. Each state has regulated their own environmental standards, requirements. We have the FAA, sorry, that is one of the most strict regulations in environmental concerns with this environmental impact assessment, and so on. This leads to the fragmentation of international space law. Each states decide how they are going to act and behave in outer space. Of course, we do have the non-legally binding instruments, resolutions, declarations, and on, but this brings another problem: forum shopping. There could be some sort of race to the bottom legislation under international law, or well, let's say states choosing their own requirements to attract business companies. So it's very interesting because it states what they are going to try is to develop their space sector, their space industry, and of course the lower requirements, environmental requirements, how to operate in outer space or how to launch a vehicle to outer space, space object, how to operate the dimensions of the satellites is going to be important. So there is a race to the bottom to see like, okay, the less legislation and requirements I have, the more companies they can be attracted by this. This happened, although this is a controversial dispute and debate. I'm aware of this with strong technologies, right? The ACC decided that strong technologies could not launch their space beasts, which they were, I think, more or less like this. Again, this beautiful cap, more or less like this. They were very small. It was very difficult to track. It could cause environmental damage due to collisions to other space objects. So the FCC decided that they were not authorized to launch the space beast. Then Strong Technologies got the launching in India, and they launched without the authorization of the FCC. They launched from India their space beast. Nothing happened. No no collisions, no accidents. But the USA said, well, if something happened, I'm not responsible. India said, if something happened, I'm not responsible. And as you all know, states are responsible. Article 6 Outer Space Treaty. I know many people love this article. They are responsible, international responsible and liable. Article 7 Outer Space Treaty and Liability Convention, or what the non-state actors do in outer space. Well, now the FCC in the end find swarm technologies based basically in this personal jurisdiction that retains jurisdiction over the nationals. So this is very interesting on how it enforces the law this in this case, because then we do have, on the other hand, the Dish network in 2023. I remember it was October when this happened, and the federal, let's say the FCC, Federal Communications Commission, the USA, finds Dish network 150,000 dollars. And why? It was, they failure to properly, let's say, remove the EcoStar 7 from geostationary orbit to this graveyard that you all know that there is there. In the end, they admit liability dish for leaving this EcoStar 7, just 120, well, just say, just 122 kilometers above its agreed upon operational geostationary, right, Mark? So it's very important because even though we do have non-legally binding mitigation guidelines, for instance, the long-term guidelines, each state should not have to, but could integrate those guidelines under national law. And these were, of course, by the FCC, FAA. It depends on what are we talking about, the launch of a space object or the operation of a satellite. So we can see that even though they are not legally binding, they are going through a national legislation, and then they become legally binding under national, under let's say national. So then, as a space lawyer, you have to think about how can we, what can we do? What an international space lawyer should do. Let's say your states need to. You have to go to the International Court of Justice. You have to go to the Permanent Court of Arbitration, and on, right? So there is, I put you here two solutions. We have been centering around, and we have been focusing only in treaty law, which is international conventional law. But there are other sources of international law, and that's something we have to focus. There is the big forgotten, or always the most forgotten, let's say, source of international space law. I'm talking about space law, not public international law. It's customary international law. So there is this, the long-term sustainability guidelines that I mentioned quite a while and many times. They are not legally binding, but they have a normative body. This means that it seems like they are crystallizing, or they might have crystallized, or even help to create a new customary international law. This is the most forgotten source of international space law, customary international law, and they have the same value as treaties. They are international legally binding. Well, these long-term sustainability guidelines is very interesting because they have their own term for what it means space sustainability. It is based, of course, in the concept of sustainable development on Earth, but is adjusted to outer space, right? So, of course, it integrates principles of sustainable development, such as the intergenerational and intra-generational equity, useful uses of outer space in a way, in a manner that we can keep using it in an indefinite way. So what we can see here, when you see the opinion juris or the negotiation process of these long-term sustainability guidelines and what the states are doing nowadays, we can talk also about the asset test of 2021 of Russia. You can reach me out and we can comment on that, if it breaks this rule or not, if there is a breach or not. But this concept of sustainable development, sustainable space sustainability under the long-term sustainability guidelines, when you see the negotiation process and you see which delegations say what and their position, it seems that there is a common agreement on what is space sustainability and the concept of space sustainability. And let's see what is the state practice of this. But it seems like there is a new emerging concept of space sustainability that if it's breached, it creates international responsibility for the states that breach this concept, because it seems like it's an emerging consumer international law. And as a lawyer, when you go to the International Court of Justice, if there is another massive asset test that disable and well, not disable just the satellite, but put in danger, in grave danger, outer space environment, you can use that to say, well, let's analyze if if this is the um, uh, if this concept is already consumer international law or not. What is the problem that we have in international law, that unless the International Court of Justice or even the International Tribunal Law of the Sea said what is consumer international law or not, we can only speculate. We can only just debate. There is another solution, and I really love this one personally. Many people are always focused in Article 6, 7 of Outer Space Treaty, but there is another article even that can be even more important sometimes. Just sometimes is um, the Article 3 Outer Space Treaty, which means apply international law, public international law, also general international law to outer space activities. What does it mean? That we can apply other branches of public international law to outer space environment. And this is quite interesting, not only because the law of armed conflict that I taught, because other branches that protect or might protect outer space can be applied. What do you think, which kind of branches of international law? International Environmental Law, IEL. That's what you see there. Now, when you apply international environmental law, and that's something that I've been defending now for ages, when you apply international environmental law, you can just not apply it, just like that. Let's apply it, right? You will have a bunch of treaty law, like the Paris Agreement, Biodiversity Convention. How are you going to apply that, right? We don't have whales or fox or deers or turtles in the moon or on Mars. We don't have climate change like that, as in the Paris Agreement and their objectives in Mars, right? As put it, right, in the Paris Agreement. Now we have principles such as the polluter-based principle, precautionary principle, prevention principle. We have the sustainable development principle, and this is very beautiful because they can protect outer space environment when it applies to space activities. Now, what is interesting is that they are applied, they can be applied to outer space activities, but in order to do so, some of them are functional and not functional. Why I say so? Because you cannot apply, for instance, sustainable development in its full, as a whole, to outer space. I know that, for instance, the cislunar space, for instance, the Lagrange points, and the and the Earth orbits, LEO, and so forth, they are a finite resource, a limited resource, but the rest is infinite. So careful, when you apply sustainable development, because But on the other hand, for instance, the precautionary principle, the prevention principle, they can be fully applied to outer space. Now, the problem here is that when I say functional, it's functional when you see it there in the slide. The problem is that even though they can be applied, they might be not fully applicable. And why? Basically, is because you have to analyze their legally binding force under international earth law. Article 3 applies everything, but you have to discriminate whether, for instance, the precautionary principle is part of consumer international law and the public international law or not. And you will see that there are many differences, many views, even with the polluter-pays principle. The one that pollutes pays, right? But who are you going to pay? There is no sovereignty right over outer space. There is no an international authority that rules outer space that we can pay and then distribute the benefits of that payment to many other states so they can create new capabilities to access to outer space, or they increase their technology. We cannot own outer space. So how are we going to apply polluter pays principle? So then, of course, you also have to figure out whether polluter pays principle is legally binding or not. The same applies to prevention principle and precautionary principle. And if they are, of course, it's going to be used. Precautionary principle and prevention principle find its expression also in the environmental impact assessment. This has a lot of discussion. I'm trying to simplify as much as possible. But in the end, um, you know, these principles are integrated through the license regime that mandates Article 6 authorization, licensing regime. So, for instance, the FCC with these guidelines that they pass, or the FAA, you have to pass through several environmental standards in order to launch or operate a space vehicle, a space object. Even at the end of their life, you have to do several things. So, I mean, this is very interesting. If you have any doubt or whatever about this, just reach me out, because this is very interesting. This perspective of space sustainability under international space law. There is another part that I wanted to remark. Another dimension we can go pass through this very fast, which is the connection that has other area of space. And we actually tackle an approach in this panel of international space security, or space security, national space security, this track in Maine Space Conference. It was wonderful. It's space security. There is another dimension of space sustainability that they are really connected to each other. We don't have any threats, but if we, for instance, this is the connection I'm explaining right now. If we don't have, or we take care of our Earth orbits, it will have a direct impact on space security. What we want with space security is basically a peaceful use of outer space, a safe outer space, right? And with no threats, safe, peaceful, that we can keep free from threats. And these threats are coming, for instance, this asset test that we have seen before, this militarization of outer space. But I'm talking this branch of militarization of outer space. I'm just not talking about satellites. That, by the way, 95% of the satellites in orbit are with dual purposes. That's very interesting and fascinating to think about. I'm talking about missiles, or even interceptors. I think you guys, I talked with Rebecca about this. We confirmed this. You guys have in Alaska and California interceptors, ballistic interceptors, missiles, that it can explode. It can intercept a missile in outer space, and that can create also debris in outer space. So the more debris, the more affected is space security, because we are not reaching that space sustainability, that safe environment for all. So, of course, we have this militarization, we have the weaponization of outer space. Can we explode a nuclear weapon in outer space? Well, outer space treaty, you know what it says? You cannot place weapons of mass destruction, of nuclear weapons, in outer space celestial bodies. But the outer space treaty doesn't say anything related to what? The use of nuclear weapons or nuclear devices. Once again, we have to go to Article 3 that I mentioned, and that's why I love this treaty. And it says, apply the public international law or general public international law, apply to outer space activities. This includes the nuclear partial test treaty ban, PTBT, I think it's called, or PNTT, from 1963, and also the prohibition of the legal use of force. I guess this is of interest for you for this lecture of space security that connects space sustainability. Once again, a better safe assets, the more sustainability of outer space, less risk to operate in outer space, to navigate through outer space. So coming back, when you apply international law, and then also the United Nations Charter, it says prohibition of the illegal use of force, and also this partial test treaty ban from 1963 is prohibit nuclear explosions. Therefore, the use of nuclear energy explosions, even though it's a weapon or a nuclear device in outer space. So we cannot do this Armageddon things that we are going to see later, which seems absurd, right? What if a space object, an asteroid, for instance, or a big space object, what would it happen if it's going to collide or if going to destroy the Earth? And we cannot use this because we have to respect international law as a matter of space security and also space sustainability. Well, the United Nations Security Council, it can authorize the use of nuclear weapons in outer space. This is also very controversial, for instance, for planetary protection. Right. We also do have, when we talk about space sustainability and space security, we also do have this cislunar space. That's obvious. We have to keep, we have to defend, we have to protect the space between the moon, between the Earth. This is the cislunar space, also considering, for instance, the orbit of the moon, and especially, when you talk about the cislunar space, which is very hostile for the operation of satellites and on, even the next, Artemis missions, you have 5 Lagrange points. Let's say calm points that you can see there, and they are very desirable by states. Nowadays, we have DARPA. We also have as I remember, the Air Force's lab for the USA, that they are trying to create these patrols or sentinels to protect these 5 Lagrange points because they are very desired by their own characteristics. I'm gonna get there. It's about gravitational forces, low maintenance of fuel, right? They're more stable. They are more stable points. So of course, the security of these places means to keep a safe and sustainable use of those Lagrange points and cislunar space, so we can operate. There is another threat that can disturb the sustainability of outer space by means of keeping a permanent presence of humans in outer space free from threats, and it's the detection of extraterrestrial intelligent life. We are going to get back there later. We already talked about planetary issues, planetary protection, and so forth, and then the cislunar space, right? As you can see here. Now, when we tackle space sustainability, space security, we talk mainly about international space law, right? We have approached this issue under international space law. And international space law means states and states. It does not comprehend a non-state actor involving into state-to-state activities. Of course, many of you will be like, what? We have SpaceX providing essential services to NASA. We have ULA, for instance, you see it there. And that's a problem. I'm aware of that. Nowadays, 75% of the space economy is made up, consists on the actions and activities of private space actors, 75, 80%. This is incredible. And they are not involved in international space law, state to state. It's different. If you ask me, well, what happens with these long-term sustainability guidelines, right? or these other guidelines where there is a bottom-up process where private actors are asked for suggestions, how they want to be operated in outer space, what are going to be the set of rules to behave responsibly in outer space, right? I probably most of you think, well, we should integrate, we should get involved in the private industry in international space law. That's right. That's right. And basically for two reasons: space security reasons and space sustainability reasons. Nowadays, as I mentioned earlier, um, commercial actors or private space actors are providing essential infrastructures to access to outer space and also satellites to states. And they are a huge part of the space economy. They can even, they have more capabilities than many states. Nothing stops to Blue Origin or even Virgin Galactic or SpaceX to launch a missile from their base to shoot down someone else. When I say someone else, state space active satellites or non-active, or even a commercial space station in the future, etc., etc. Nothing stopped them. When I say nothing, is that they can actually do it. Of course, there will be consequences, but they are also not interested. They want to have a sustainable space environment for just one reason: the cost of access to outer space is high. Commercial space sector, they are not going to engage into a conflict. They are not going to diminish. I think it says, right. They are not going to be interested in create conflict, or conflict that is translated into huge, large amounts of space debris around the Earth, because the safety of the space environment will be worse. There will be not investment if my satellites are going to be destroyed easily, right? So we have to see these commercial space actors as the real actors in outer space, and they have full capabilities of launching, for instance, missile to outer space. Are they going to do it? Probably not. They are not interested in engaging this kind of conflict in outer space because they have self-interest, space economy, space investment, and when you talk about space economy and space investment, this is not, for instance, I have a building here on my left full of students, and when you build a building, the return of investment can be fast, 1, 2, 3 years. In space, it's not like that. Just imagine for a moment how much time it took to Elon Musk to build the Falcon, just not Falcon 1, to launch properly a Falcon 9 with the re-entry, which is really awesome to see. I saw it from the Kennedy Space Center this year in 2024. It was amazing. It was more amazing even than the proper launch. To the Starship, it's been 2 decades, more than 2 decades. So, having those contracts from NASA or other entities is something that they are eager to get. So they are not going to engage that easily. We can also talk for an international affairs or international relations perspective, diplomacy perspective also, but mostly from international perspective, international affairs, international relationship perspective. Those other states that they might be interested in engaged conflict in outer space, but also let's say, this comes to the next slide. There are other states that they are fully not. They don't want to get into this conflict. For instance, Russia, China, the USA, India, Japan. Let's call the EU ESA, because their economies and they depend on outer space, right? So this is very interesting. We have been talking about the weaponization of outer space, militarization of outer space. This right of self-defense. You have to correct that, not to self-defense. The use bellum, which we talk about this, right? We have talked about the long-term sustainability guidelines that you can see in this slide, Lagrange points. I was quite anticipating here, but there are several states what I'm talking here that they might be interested in engaging in conflict. For instance, North Korea, Iran. They don't have a lot of space assets in outer space. Not just they don't have space assets, is that they don't have huge interest. They can launch a missile. It could be very imprecise, that missile to outer space, explode. Uh, but after that, you know, the military from the USA could invade the country, could justify this aggression as mean of as a way to justify self-defense, engage even in a war, which could be justified. In this panel that I'm referring constantly in the main space conference, Professor Larry, I remember, was talking about also cyber security and cyber attacks. Well, the International Red Cross Committee said, and this is very important because we are just not talking about missiles, we are talking about something we don't see properly. The attack is very difficult to identify the attacker, but launching these kind of attacks that can disable a satellite, blind a satellite. These cyber attacks, when they affect essential infrastructure on Earth, that they are vitals, they can be, and this is very interesting, they can be an armed attack and then trigger what we talked before, the use ad bellum, the right of self-defense, but also next to that, the use in bellum, when we decide to get into a war in a justified way. Right? So we have this kind of role or hostile states that they could engage in conflict, and then of course they could create a problem when it comes to space sustainability, because missiles is not only cyber attacks. That cyber attacks, they do not strike a missile, but they can deactivate or disable a commercial space station, for instance, or a satellite, and then enable to maneuver and then collide with other space objects. Worse outer space environment, no space sustainability. Right? I hope you don't have any question here. I mean, if you do any doubt, sorry, but if you have any question, please feel free. Then the other states, as I said, Russia, India, China, the USA, Japan, they are not interested in engaging in an actual war in outer space, in actual conflict. As I said, commercial space actors, they are not going to engage with that. This is called, some authors call it, I don't remember which author, call it space economic peace, this theory. And that's partially true. I mean, not partially, probably it's entirely true. There are many interests in outer space, especially investment, economic interest, and also, for instance, military interest. For instance, when you engage in fire on Earth, for instance, you have to. I realize I said many times, for instance, but for example, when you target in a conflict on Earth, when you target specific objectives or objects, this precision is given you through a satellite that you are using. Of course, we could talk about the Gulf War, the first, let's say, space war. Doesn't, I mean, we cannot. If you are interested, just reach me out. And well, yeah. So you could talk more about how can we target and how can we apply law of the armed conflict principles. For instance, the distinction, instead of massacring the entire environment surrounding people, or just a lot about civilians, using space technology for military purposes can target specific points. There is something that I want to, that I was mistaken. I said it right during the panel, but what I meant by planetary defense, it means planetary defense, not planetary protection. There is a difference, right? between planetary protection and defense. Protection is the skylines, coast part, extraterrestrial contamination, and on, both for when an object comes from Earth to from outer space to Earth, there is a whole protocol to the disinfected, and we do have the reverse. When we go to Mars, be careful how we are going to contaminate. What I was mentioning is, for instance, I think it's in the next slide, just to finish this. Yes, we have the planetary defense, and it's more about this Armageddon thing. We do have also this mission succeed by NASA DART that try to divert an asteroid coming to Earth in the future. And then now ERA by ESA that is going to analyze. So there is a difference, right? Planetary protection is a completely different thing than planetary defense. Now, another threat that can impact the last threat of in outer space and the sustainability of outer space, and is the detection of extraterrestrial intelligent life. Okay, this is, as I said during the conference, this is not a Comic-Con, all right? But just so you know, the international community thought about this. What if there is a detection of intelligent life that can threat the sustainability of outer space, the human's life in outer space, the Earth, space objects, satellites, stations, and on and on and on. So it's very interesting. I could not develop this idea during the conference, but just so you know that there is some protocols and declarations at the international level, non-legally binding, that from 1989, 1995, and then a joint declaration of principles that joined these efforts in the post-detection 1989 and communication 1995. And it's very interesting because we usually imagine what if there is extraterrestrial life coming, right? Like Mars attack, for instance, not like ET, because that's kind of soft and warm, you know. We all remember. Or signals, you know, like alien invasion species that could threat the entire outer space ecosystem. So first, when we detect that extraterrestrial intelligent life, we have to verify this signal. We have to make sure that this signal is real. It's coming from an intelligent life. And then after that, you know, we have to communicate under outer space treaty obligations. We have to notify the United Nations. We have to notify the media, the people, and on. Now, the problem is when we have to reply, or if we do it, we have to reply to this extraterrestrial intelligent life, right? What are we going to communicate to them? The problem is that this bunch of non-legally binding instruments, they are not legally binding. It does not force to states, not even actors, private actors, to provide a common answer. And what you are going to broadcast to outer space and this extraterrestrial intelligent life people is on behalf of humankind. So there's nothing that stop commercial space actors to provide their most benefit answer to extraterrestrial intelligent life. This is highly interesting, right? Of course, the negotiation process usually should be carried out under COPUOS or United Nations. Better, because all states, 195, they are represented in United Nations, but not in COPUOS. Should, you know, negotiate a common answer on behalf of humankind. This is a very interesting topic. If you want further information, let me know. And, you know, in the end, as I said, we have these dimensions. That is the detection of extraterrestrial intelligent life. We have planetary defense, not protection. We have militarization of outer space, conflict in outer space, that they can have a negative impact on the sustainability of outer space. There is one last thing that I want to mention, and I talk about this with other colleagues in Maine, is that outer space law is not made anymore couples. We have the Committee of Disarmament, the first committee of the United Nations, the Conference of Disarmament. We have also the United Nations Security Council that, when it comes to weapons of mass destruction, the talks are taking place in the United Nations Security Council and the Conference of Disarmament, and also the creation of a new treaty, legally binding, of course, that's why it's a treaty under the Vienna Convention on the Law of Treaties. For instance, China and Russia, they are trying to push a treaty that forbids some sort of the use of force, therefore some weapons, placement of weapons in outer space, so all kind of weapons. There are some drawbacks there that I mentioned in the main space conference. For instance, the verification mechanism, the lack of verification mechanism, and also which kind of arms, right, are you forbidding? Because, for instance, there is an issue with the Assad missiles or missiles, also interceptors. They could be missiles that strike a satellite that could be used as a weapon, but those interceptors are part of the national defense of each country. So I don't see the USA or other countries refusing or to give up, to these interceptors. And still, at the United Nations Security Council, they can authorize the use of force in outer space. Now, the problem, as you know, there is a blockade there because 5 of the 2 members of 1 member of the 5 states. We have Russia that it can veto any of the 5 members. They have the right to veto, and that's a problem. To put it into perspective, commercial space actors, private companies, are the most interested in preserving outer space from a sustainability point of view. More sustainable space, it means less space debris, responsible behavior in outer space, more transparency, more talks between states. So they have, commercial space actors, what they want is legal certainty, legal security. So the more states talk, the more safety is outer space, the less threats are in outer space that can damage the sustainability of outer space environment. Thank you very much. If you have any questions, you can reach me out or by my email or even my LinkedIn if you want more direct contact. I'm also at your disposal. Any questions you have, here is some questions that you can treat, and then you can ask yourself, and then Rebecca can send it to me and see how the debate went. And it's like whether conflict in outer space is avoidable, and what will space look like in the future in terms of space sustainability. Just so you know, just a couple of final remarks. Conflict in outer space will always avoidable. There will be always a solution, and all the international legal mechanisms, they always opt for a peaceful use of dispute settlement. Always try to go to peaceful means. Even though when you can trigger the right of self-defense or the law of conflict. And then, what will space look like in the future? We are talking about 2030, with this objective of main space. But also we are talking about 2050, 2060. We will have more activities under the emerging space industries. We will see human settlements, how they are going to protect those human space settlements under international environmental law, under international space law. Even these ideas taken by Michelle during the conference of due regard, or this concept, this very amazing concept of protecting heritage in Moon. So these are issues that they tackle directly to space sustainability or space security. Thank you, everybody. If you have any questions, please reach me out.